Judges, Judge Armstrong, Judge Stafford, I've been before you before, probably in your trial court days as well. Judge McGee, I think this is my first time maybe to be in front of you. But thank you for your consideration in this matter. Now, I'm going to try to be...
You need to introduce yourself and tell me if you want rebuttal time first.
My name is Andrew Owens. I'll take 3 minutes of rebuttal.
All right.
I told myself there were 2 things I needed to do, and I forgot. We're here, as your honors know from our briefs. It's a fairly straightforward matter, and I'm going to try to get to the point. A judgment was taken on June the 2nd, 2022 against my client, Ms. Pesce. It was taken, no one disputes it was taken without notice to us. This was during COVID, and the General Sessions courts were taking things off their calendar, and at its pleasure was sending out COVID reset notices. Now, my client accepted service. Apparently she's got a friendly relationship with Attorney Jeff Germany, and he accepted service for her of the civil warrant. But then the court, of course, takes these off the docket to be reset through a COVID reset letter. I defended Ms. Pesce, and I filed a notice of appearance with the court in July of 2021, sent that by mail to Mr. Wells. That's never been denied. Almost a year later, a judgment is taken against Ms. Pesce, and it came about because the clerk did not send me the notice. As a matter of fact, they sent it to the wrong address of my client. They picked a street name out of, I don't know where that came from, but it's not the street name on the civil warrant, or it's certainly in Mr. Germany's law firm, but it went out nonetheless. I found out months later about this judgment, but I noticed one thing. There were 2 defendants in this case, my client and a lady named Miss Weaver. She was driving another vehicle. This is a motor vehicle accident for damages that Miss Bradley alleges from this accident. So it was a 3-vehicle accident. And I noticed that there was no disposition taken as to Miss Weaver. I mentioned in my brief, I might have been a little bit out of line, but my dad got me a summer job in 1973 before my 2nd year of college. As a summer clerk in General Sessions Court. Oni Hall, I believe, was the clerk then. Jean Goldsby was her assistant, and sat in the courtroom. They had summer people sitting in the courtroom. And I saw time after time, I've been at this now 40 years, I saw time after time a lawyer would come in, take a judgment against the defendant, and the judge would say, what about these other defendants that aren't served? And the lawyer would say, oh, Your Honor, we'll take a non-suit. And they did that because they knew that to have a final judgment that they could execute on, that all parties had to be disposed of. Well, that was not done in this matter. On June the 2nd, 2022, and I didn't mention this in my brief, but it's in the record, the court set the matter for trial. So this was a trial date. And on trial dates, what happens? Everybody in the case gets disposed of somehow. Interestingly, on that date, there were 2 defendants, both of whom the statute of limitations had run on. As one of the error that we claim today is the judge's failure to grant our motion to dismiss. The alias civil warrant for my client was filed more than 9 months after the previous return of service. And I've cited all that in my brief, the General Sessions statute that says that aliases must be issued within 9 months of the return of the previous one. So interestingly, there's 2 defendants on June 2nd, 2022 that the statute of limitations has run on, but mine's the only one served. So a judgment is taken against her and nothing is done as to Ms. Weaver. I found out about it and I filed a motion in General Sessions Court to set aside the judgment against my client. And the judge heard it because the judge knew he had jurisdiction. The judge knew that this case was still in his court. He ruled against me on my motion, but at that time, on January the 5th, 2023, he entered a voluntary non-suit against Miss Weaver. And our position is, and we think the law is clear, that that's when I had an appealable judgment from Ms. Pesce. We appealed within 10 days of that, and Judge Dandridge did what she did, which is what we're here appealing. Mr. Wells dismissed us, filed a motion to dismiss, claiming our appeal was late. And we are taking the position, and took the position before Judge Dandridge, that it's not late. It wasn't appealable until January of 2013. And moreover, the statute of limitations had run. And that's not disputed, that the alias was filed outside, the alias as to us was filed outside the 9 months. So that's where we are. Now, and the reason those good lawyers, when I was in 1973 and all the way up until today, and the reason the judges asked them, why, what are you going to do? They've just rendered judgment against one defendant, and they ask, what are you going to do about these other defendants? Because everybody knew you can't have part of a case hanging around. You could have multiple trials in the case. What if a person who's not served yet gets served later? Can the plaintiff come back and have another trial? Imagine how many, you could have as many trials as you have defendants if it were not a logical requirement that all parties be disposed of before it is appealable. Now, we've cited the Leak case, and we think that's directly on point. Someone appealed a unfavorable decision to circuit court from General Sessions Court. The circuit court said, no, you're too late. It goes up to the Court of Appeals, and the Court of Appeals said not only was it not late, it was premature, because one of the parties in that case had not been disposed of. So if we had appealed before the non-suit as to Ms. Weaver, this court would have, under the Leak case, would have called us premature. Tennessee, and I didn't cite this in my brief, but it's a statute, Tennessee Code Annotated 275108, which was amended in 2018. You know, from time immemorial, it had always been the rule in General Sessions Court, if one appeals, they all appeal. And then a lawyer who became a judge wrote a bar article that said, no, I think that's wrong, and she looked at law 100 years old. But anyway, the Court of Appeals got it back to the way it had always been. One appeals, it all goes up. There are no longer cross appeals or anything like that. So how could we have appealed under that? What would have happened to Ms. Weaver? There'd been no resolution of that. You can't have some of a case pending in General Sessions Court and some of that same case pending in circuit court.
You can do it in the trial court.
Pardon?
You can do it in the trial court.
I'm sorry, Judge.
You can do it in the trial court.
Do you mean?
Have one part of a case pending in the trial court and part of it pending in the Court of Appeals.
Well, that may be the case, but
Rule 54.02.
That's right. That's right. But you can't have a trial in the Court of Appeals. In other words, we're not in two courts. We're in both courts. You can have trials.
Does it matter about whether the rules of civil procedure are applicable in General Sessions Court?
I don't see those as being applicable. I know that there's a statute that says that Rule 60 can be made applicable if you file a motion within 10 days in General Sessions Court, but we didn't even know about the judgment for months. So Your Honor may be laying a trap for me, but I don't.
Just asking a question.
Thank you. But
let's see, I know you cited Leak. Have you found any cases after Leak that addresses this question about when you can appeal a case from General Sessions?
Your Honor, that is the only case, and I'm surprised I found it. I was surprised to find something on point about that. But as I've said, it was consistent with the procedure down there. It's consistent with the way things have always been done. There were 2 cases still alive on June 2nd, 2022, when that judgment was taken against my client. Now, Mr. Wells mentions in his brief, well, the statute of limitations had run against Ms. Weaver, so it wasn't alive. Well, it didn't run as to my client, too. But as the court knows, statutes of limitations are they're affirmative defenses. And this Court of Appeals has ruled that that can be waived. It's not jurisdictional. So somebody could have come in later and taken a judgment against Ms. Weaver in spite of the statute of limitations if she didn't show up if they got service on her and she didn't show up to defend herself. So 2 cases. Our position in this matter is, from Ms. Weaver's not much different, but hers had to be disposed of, or any appeal prior to that would have been premature. And again, and then I'll.
And that's a holding in leak, is that right?
Pardon?
That's a holding in leak.
That's the holding, and yes, I'm having a senior moment. In leak, yes, that's the holding in leak. The Court of Appeals said, Court of Appeals said, no, this appeal to circuit wasn't late. It's premature. It was not ready to be appealed. So, unless there are any questions, that's my presentation.
Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, my name is Murray Wells. I'm from the Memphis-Shelby County Bar. I've certainly practiced in front of Judge Armstrong, Judge Stafford, and likewise, I don't know, Judge McGee. I've had the pleasure of appearing in front of you. Glad to be here today. Under the appellant's theory of the law, well, they want you to create law, that a judgment against a defendant cannot be appealed as long as there is another unserved defendant in perpetuity. That is the rule they're asking you to create. They want you to find that if you take a judgment against a defendant, that defendant is barred somehow from taking an appeal. And I would submit to you, that's not what leak says. Leak is an entirely different matter. Leak, the party that was arguing about service appeared. They showed up in court and they filed a motion to dismiss for lack of proper service. That order dismissing that case was appealed by the plaintiffs while the other party was still active and alive and had noticed and was litigating in general sessions. This is not leak. This is a different situation entirely.
How does the holding differ?
Well, the holding is different is because there were 2 active litigants downstairs, and they said because there are parties down here, you've got to wait until the other active participant is resolved. It would sort of not make any sense if there wasn't some other active participant.
Well, I've read that, and it's been some time since I've read it, but I don't remember that distinction.
Well, I've read it in the case, and I'd say that it's very clear that both parties, both defendants in the leak matter, filed notices of appearance or appeared and participated in that litigation. That's big distinction, number one, because to find something else, you've got to find that you can sit around forever and the defendant's right to appeal his case. If a plaintiff chooses to never serve another named defendant in a lawsuit, that other defendant never has an opportunity to appeal the case. It just sits there, right?
Well, I don't know that that's accurate, but go ahead.
Well, I don't know how else you would do it.
I mean, the statute of limitations, if you don't ever serve the other party, the statute will run and it'll become barred.
Well, exactly, sure.
So then it's an appealable judgment.
That happened here. That's this case. That's right. If the argument is that once the statute runs, I mean, we filed the general sessions warrant in March 10th of 2020, okay? The appeal wasn't taken until the appeal file was filed on January 9th of 2023. There was no, this person had never been served for nearly 4 years. So that's, the case you're describing is this case. And I want to go back and touch on something else, if Your Honor pleases, that there was this argument about these good lawyers back in the 70s and 80s, and I didn't know whether to take some umbrage with that or not. But I would point out to the court that...
No offense was made. I apologize if it sounded like an insult.
Appreciate that. Go ahead.
I would simply point out that the argument that somehow you file a notice of appearance in a case and let it sit there and then let a judgment get taken. This matter was reset time after time and time, and that's in the record. And I know because I was there time after time after time in this case.
But that's a slippery slope I don't think you want to get on, because if you file a notice of appearance, you're supposed to get notice of the hearing. And, I mean, the allegation from the other side is, I never got notice.
Well, if you're already going to get notice, there's a way to do that, and that's simply log into the computer on a case that you've had for a year and see if it's been set. Or to communicate with your client to see if they've gotten some kind of notice, if you're worried that it's going to the wrong address. Or to make sure that the General Sessions Court has the proper address so that you do get notice. What you don't do is nothing. And so past that slippery slope, I understand. In terms of what happened, judgment was taken. I don't know when Mr. Owens learned about the judgment, and I don't know why it took months for him to find out about the judgment. I don't know. But he did go back to Judge Thompson. We specially said it, and we re-argued the same issue again. And Judge Thompson was very clear that no, the June 5th date was the date the judgment was entered against your client and became final. At that point, when the judge made that ruling that the judgment was final as to them on June 5th, absolutely, I non-suited the party that I was never going to serve, that I couldn't serve, that was 3 years gone by, to clear it up. And when we went to the circuit court in front of Judge Dandridge, we didn't hear arguments about statute. As a matter of fact, that was the first time that this service issue was ever raised, was by motion by Ms. Pesce. At circuit court, the judge didn't even hear that. I mean, the judge issued an order, but if you read the transcript, and the fact that there was a 2-week difference in between the orders that went out, the judge said, look, I just don't have jurisdiction. It's been here. Another judge, the final judgment was June 5th. And so this isn't a leak situation because those parties were active litigants, all parties. And there is no case law where non-active litigants can preclude someone else regardless of how long statute goes. So with that, I would submit, and I would thank you for your time unless you have questions.
Well, I do have a question.
Sure.
You go ahead, though.
Was leak argued before the trial court?
No. Well, before the trial court, he may have argued it at the trial court, and I don't remember. I've got the brief here, and I can pull it up.
But the trial court in her order doesn't even mention leak and try to distinguish it from the facts in this case, because it appears that it would apply, but the trial court doesn't address it.
I'm not sure how leak does apply. The only thing that I can see about leak that is that while there's an ongoing case in General Sessions, one party can't appeal. We don't have that here. There was no ongoing litigation. Nothing was happening. That person could never be served, ever. It would be a legal impossibility. Time had gone by. So I don't remember if leak, it wasn't raised by Mary Bradley. Ms. Pesce may have raised it in their brief, and I think that would be in the record.
Is there a difference between what constitutes a final judgment in General Sessions Court and in the courts of record?
I don't know that there is. I mean, differences in your timing for appeal and where you go, and then what the review process is. So I think all
No,
that
just
changes.
what
Final judgment's
constitutes a
a final
final
judgment is a
judgment.
final judgment. I don't understand the difference.
I'm sorry?
I don't understand the difference between the two.
Oh, okay. Okay. Just one second. And I asked about the rules of civil procedure, as Mr. Owens does. Does the application of the rules of civil procedure here have any impact on this particular case?
I don't believe so. And not until he attempted to bring it up to circuit court. The rules of civil procedure don't apply in general sessions.
Some do.
Sure, but generally, the rules don't apply, and the way we go around that as lawyers is we petition the court for, if we needed a deposition or something like that, the rules that civil procedure allows, we petition the general sessions judge to let us do it, but generally, no, rules of civil procedure do not apply.
Okay, thank you.
Thank you very much.
May I, Your Honor?
Yes, please.
I wish the statute of limitations was a bar, because I wouldn't be here, but it's an affirmative defense, and it's got to be raised or it can be waived. Now, this idea that a defendant can sit around and delay a plaintiff's enforcing its judgment in perpetuity, it's just not accurate. What you got to do is dispose of it as to all parties, and then you've got a final judgment. If on June the 2nd, Judge Thompson had said, "What about Miss Weaver?" and Mr. Wells had said, "Your Honor, we'll non-suit her," then 10 days later, he would have had a final judgment against my client. And not only that, he could have, under the statute, that same statute I cite that says you have to file your civil warrant, your alias, within 9 months. That also says you have another option. You can refile the lawsuit within a year from. So he had the option of non-suiting and refiling within a year against Weaver and continuing to litigate against her in a separate lawsuit. So there's no logic to the claim of a judgment defendant stalling a case in perpetuity. That's all in the plaintiff's hands, and that's why those lawyers did that. I couldn't find any. I read in Mr. Wells' brief where he talks about AT&T and the Leak case being active and litigating. I couldn't find that, and I put that in my reply brief. And sure, there are ways to. I probably could have found out that Mr. Wells had set this case and gone down a number of times. One of the ways he didn't mention would be as if my adversary had called me and let me know that it was set, which is common courtesy in our jurisdictions. First time it's ever happened to me. But in any event, that's probably neither here nor there. Leak, I can assure you, and I think you've got the entire General Sessions record, Leak was relied upon in General Sessions Court, and it was relied upon in Circuit Court as well. Thank you.
Thank you, counsel. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. We will stand in recess, Ms. Angie, to the call of the docket this afternoon.
All rise.
Thank you.